Money Radio, good afternoon, and thank you for joining us. Pleasure to welcome back Jim Knollmiller from the firm of Knollmiller and Aronofsky, legal firm located in Mesa, Knollmiller and Aronofsky, and the team at Knollmiller and Aronofsky specializes in estate planning. Also, Jim, you're a CPA, so you do taxes as well, and those two really go together hand in glove, because if something changes in your taxes, there's a good chance that you need to reflect that change in your estate plan as well.
That's correct, Sinclair, because today taxes are a major issue in estate planning. It's not the estate tax, it's the income tax that becomes a greater emphasis, and because many people have a significant portion of their estate in retirement accounts, these accounts are generally subject to income taxes, as well as estate taxes if you have a large enough estate.
And also, it's so important to understand just what is changing in the law at any given time. There was a very important case, I think, for a lot of people, the Supreme Court ruled on in this last session. That was the case of Clark v. Ramaker, and it dealt with inherited IRAs. Very briefly, the case dealt with a married woman. She and her husband had started a pizza shop. They went through some difficult times, eventually declared bankruptcy, but before that happened, she inherited from her mother, I believe, about $300,000, and it came to her via an IRA. And so then when the pizza shop went into bankruptcy, the courts looked at it and said, oh, there's some money over there. Let's talk about what happened and what the implications are.
Okay, the Supreme Court, in this case, there were two conflicting court decisions. One said this was exempt from creditor claims, and the other said it was not exempt. Well, the final decision the Supreme Court came down in June said inherited IRAs are not exempt from the bankruptcy, so that if you inherit an IRA from your mother or father, then your creditors can reach it. So in this case, the creditors of the family could reach this IRA account. Now, we have some fortunate thing in Arizona, because Arizona has a statute that provides that retirement account benefits are exempt from creditor claims not only for the participant but for the beneficiary. Arizona is one of the very few states that has a law like that. However, the majority of the estates, that is not true. So if you inherit an IRA, and this could even be a spouse that inherits an IRA, could be subject to creditor claims, and this is a completely new decision that people need to take into account in doing their planning. If they have retirement accounts, there are ways for them to protect their beneficiaries from any creditor claims, regardless of what state they live in.
We're looking at some different rules when you're inheriting an IRA or 401k from one spouse to another spouse, or when you're inheriting it from someone else, say a parent, aunt, uncle, or even someone not related to you. There are some ways that it can be done to be protected, but you have to make sure that you get that right.
That's right, Sinclair, because normally if it's a spouse as a beneficiary, he or she can do one of two things. They can leave it in the deceased spouse's name, or they can roll it over into their own IRA. Again, in Arizona, that rollover or leaving the deceased spouse's IRA will still be creditor protected. That's not true in other states. And in this ruling, there were several things that brought out that even a rollover from a spouse could be subject to creditor claims in certain states because there's a 10-year statute. So if you do the rollover and 9 years from now went bankrupt, your creditors might reach this asset.
A look-back period.
A look-back.
Okay.
So this is very important for individuals who have retirement plans to look at the beneficiary designation and consider other ways of protecting it. What we recommend is they consider a special type of trust for their beneficiary that will enable the beneficiary to stretch the payments out over his or her life expectancy and protect the money in the account from creditor claims. I call it the fruit and tree doctrine. The tree is protected. Once you distribute the fruit out to the individual, the creditors can take the fruit.
Right.
But you're protecting the tree because that's the major source of income. So anyone who has a significant IRA account or retirement account and are leaving that account to even a spouse, or particularly if they're leaving to a non-spouse, they should look into what form of beneficiary designation they have and consider this special form of trust.
You bring up a good point. We have some protections in Arizona, but what if someone has other assets outside of the state, or this involves an inheritance from someone not living in Arizona? Some issues like that come into play as well. All of a sudden, this can start to get a little bit complicated, but this is something you need to think about, and not just with the idea of, well, I'll protect it from creditors in bankruptcy, because hopefully a lot of the Money Radio listeners right now are never going to have to face bankruptcy. But there are a lot of other issues on how to properly roll over, how best to transfer in an inheritance, what to do when you're planning an estate and want to pass along an IRA or a 401k. I guess the point here is you really have to know the law, and the law is constantly changing. And even if you work with a good financial advisor, it's always a good idea to get a second opinion and get that from someone who can give you a legal opinion on the matter.
That's correct, Sinclair, because I've done a number of these, probably hundreds of these trusts in my career. And when we say bankruptcy, that's just one issue. I'm finding that probably divorce and a spouse who would like to get a hold of your child's inheritance is probably more of the concern you have than you would maybe bankruptcy.
Yeah.
As today, that is a common occurrence.
If you have an estate plan and would like to have a review, the number at Knollmiller and Aronofsky, 480-345-0444. That's 480-345-0444. Call and arrange a Get Acquainted meeting, 480-345-0444. And the website, if you'd like to find out more about estate planning, go to aboutestateplanning.com. Aboutestateplanning.com. Jim Knollmiller from Knollmiller and Aronofsky, always a pleasure. Thank you, Jim. Good to see you.
Thank you, Sinclair.